Welcome back. In this section, we're going to go over the UCC1 financing statement. And the UCC1 is a very important part of the secure party process. It gives your notice to the public of your priority interest in your property. And let's just begin. I'm going to come from your section in your course section. You can download this also from your course section. And I'm going to be reading right from the course section in your SPC University course units. So let's jump right in and let's begin. The UCC financing statement, perfecting legally establishing the security interest by filing. Other than by perfecting by control, delivery, and possession, the secure party can perfect the security interest in most types of collateral by filing a UCC1 financing statement. The UCC filing office is a public venue for the registration of notices of private contracts and the priority interest in property. One of the many issues you will face in securing your status as having priority interest in your property is the refusal of some clerks in certain jurisdictions to file your financing statement. In these jurisdictions, they consider these type of filings to be strawman filings and an attempt to evade paying taxes. In other words, tax evasion. The clerk will usually give you a notice from the Attorney General's office that justifies their refusal to file. This is not a law or a ruling from a court, but only an opinion. However, there is no need to get into an argument with the clerk. There are 6 different filing regions. You can simply file your UCC1 in the region of your state. And here are the different regions. And what that means is, for instance, for example, if you live in Washington State and you're having a problem filing, well, you can file in one of these other states that is considered the region and then give notice to Washington State that you have a filing in Oregon. So also, you can go on the internet and file. A lot of times you can circumvent a lot of problems in filing instead of trying to go in and go face to face with the clerk. Simply file your filing on the internet and redact your social security number and things like that so it won't draw attention to anyone, okay? And we're going to talk about some creative ways of filing your UCC1. But these are your different regions or your different filing offices here. All right. Now, since the only legal tender currency in the United States is the private script of the Federal Reserve, all exchange of this so-called money has private implications. Walker Todd was an attorney and resident expert for the Federal Reserve. In his affidavit, Walker Todd gives a description of money very aptly as follows. Relevance of subtle distinctions about types of money. And this is an excerpt from the affidavit of Walker Todd. I would strongly advise people to read that affidavit because he was an attorney and he worked for the Federal Reserve. And he sheds a light on a lot of this that we're discussing. But in this excerpt, it reads, from my study of historical and economic writings on the subject, I conclude that a common misconception about the nature of money unfortunately has been perpetuated in the U.S. monetary and banking systems, especially since the 1930s. In classical economic theory, once economic exchange has moved beyond the barter stage, there are 2 types of money, money of exchange and money of account. For nearly 300 years in both Europe and the United States, confusion about the distinctiveness of these 2 concepts has led to persistent attempts to treat money of account as the equivalent of money of exchange. In reality, especially in a fractional reserve banking system, a comparatively small amount of money of exchange, in other words, gold, silver, and official currency notes, may support a vastly larger quantity of business transactions denominated in money of account. The sum of these transactions is the sum of credit extensions in the economy. With the exception of customary stores of value like gold and silver, the monetary base of the economy largely consists of credit instruments. Hence, the advent of the prejudicial and non-judicial, in other words, private, UCC in the 1954s, and the UCC filing office, which keeps track of the ever-increasing stream of private contracts registered therein by those in the know, wherein Federal Reserve notes comprise the valuable consideration between the contracting parties. UCC filing offices provide a central form where a creditor, secured party can receive official governmental acknowledgement of the private contract between himself and a debtor, as well as an established seniority over other creditors based on date and time of filing. First in line is first in time. The foundational filing document is a simple form known as a UCC financing statement, formerly called a UCC-1 financing statement before July 1st, 2001, containing, number 1, the name of the debtor, number 2, the name of the secured party, and number 3, a sufficient indication of the property pledged by the debtor as collateral in the transaction. See UCC 9-502A. The financing statement only puts third parties on notice of the secured party's perfected security interest in the debtor's collateral. The security agreement is what creates the security interest and must reasonably identify the collateral described, whereas the financing statement can be general in its description of the collateral. See UCC 9-5042. The security agreement cannot be super generic. See UCC 9-108C, and must meet certain requirements. See UCC 9-108. But the collateral indicated in the financing statement must match up with the collateral described in the security agreement for the effectiveness of either in securing the collateral. In other words, the financing statement and the security agreement are complementary components. Neither is effective without the other. There is no requirement that a copy of the security agreement be included with the filing of the UCC financing statement. Only a sufficient indication of the collateral covered, and see UCC 502A3. The only requirements is that the security agreement must be authenticated, in other words, signed by the debtor. See UCC 9-203B3A. The financing statement must cover the collateral described in the security agreement for valid perfection of the security interest by filing. If the security agreement does not describe the collateral indicated in the financing statement, perfection cannot occur via filing because no security interest ever attached the collateral in question. Instructions for completing the UCC financing statement form. Official UCC instructions. Please read instructions for National UCC Financing Statement Form UCC-1 and instructions for National UCC Financing State Addendum Form UCC-1A Addendum. Immediately following this set of instructions, and then return and continue reading at paragraph B immediately below. No inkjet printers. Do not use an inkjet printer for printing your documents. LaserJet printers and typewriters only. Filing officers will reject inkjet printed documents because their UCC filing office computers are unable to read the text. Completing the form, standard UCC financing statement, as well as the standard filing, these instructions also cover the cross-filing and real estate filings discussed above. Please consult the sample UCC financing statement form for John Henry Doe at the bottom of the page as often as needed to confirm your understanding of the following instructions. And this section right here goes over how to fill out each one. Now, your contact information section. Box A, providing data in this box is optional. We recommend you leave it blank. Number 2, Box B. Box B is for return of the UCC financing statement form after it has been indexed, filed, and microfilmed. You may place any name and mailing location you desire for return of the form. Because some states resist doing redemption filings, you should select the most appropriate data for Box B. Number 3, Box 1A. Not applicable for our purposes. Hereinafter, put in A. Number 4, 1B. Enter all capital letters, the all caps name of your straw man, military style, last, first, middle as requested. This is the individual designation for the debtor. Number 5, Box 1C. Enter the statutory address, complete with 2-letter postal designation of the state and the ZIP, Zoning Improvement Code. That's what ZIP stands for. You may also put U.S. in the country slot if you desire. Number 6, Box 1E is not applicable. Number 8, Box 2A is non-applicable. Number 9, Box 2B. This would come into play only in the case of the secured party parent naming as an official debtor the wife, as well as any son or daughter under the age of 18. Husbands can claim wife's all caps name, but wife cannot claim husbands. The need for having to list multiple family member debtors on the UCC financing statement can be avoided by the secured party spouse or parent simply claiming all birth certificates and all of the CAP's names of desired family members as shown in the sample security agreement. Bible, thou shalt not covet thy neighbor's house, thou shalt not covet thy neighbor's wife, nor his manservant, nor his maidservant, nor his ox, nor his ass, nor anything that is thy neighbor's. Numbers 5:12-28. Note, husband and wife. A man and woman are legally married to one another and are thereby given by law specific rights and duties resulting from that relationship. The U.S. legal concept of marriage is founded in English common law. Under common law, when a man and a woman married, they became a single person in the eyes of the law. That person being the husband. The duties and benefits afforded a married woman, as well as the restrictions on her freedom, reflected this view. Even today, although the Equal Protection Clause provides that no state shall deny to any person within its jurisdiction the equal protection of the laws, U.S. Constitutional Amendment 14, subsection 1, the U.S. Supreme Court has never interpreted this to mean that states must treat husbands and wives the same. There is a strong public policy in favor of marriage. Because of this, a husband and wife are not always able to determine their duties and privileges toward one another. Instead, these rights and responsibilities are set forth by special legal principles that define the parameters within which husbands and wives must act. And you can also read in our post section, we have an article on the marriage license that I would strongly suggest that everyone take the time to read. Number 10, Box 2C. Using the technique described in Box 2B, immediately above, paragraph 9, this box would not need to be completed. If you decide to list multiple debtors, please follow the same instructions for addresses given above for Box 1C in paragraph 5. Number 11, Box 3A is non-applicable. Number 12, Box 3B. There are a number of options regarding filing in the secured party's true name, depending on the nature of the filing and any eccentricities of the UCC filing office that you are aware of. A. Standard filing. Surname in box marked individual's last name. Initial part of given name box marked first name. Second part of given name in box marked first name. And any suffix in box marked suffix. Though many secured parties may pull back from this style, we have not discovered a detriment in any proceeding. This style would undoubtedly cause less concern for a filing officer than placing the entire true name in one box as shown immediately below in paragraph 12B. B. Optional secured party filing. Complete true name, given name plus surname, initial letters only capitalized, appearing completely within the box marked individual's last name. This would be done where the filer was confident that the filing officer would not kick it back. Note, because the indexing of the secured party's name is not a crucial issue with the filing office, only secured party's surname gets indexed. Filing officers are not too stringent about this, and many people prefer not to enter their true name military style as done with trade names and other corporately colored entities. The choice is yours. Number C, cross-filing. Since the secured party will disappear as soon as the First Amendment is filed, you're free to write out this name any way you like, including placing the entire name in capital letters, which draws less attention than upper and lowercase letters. Note, some filing offices do not appreciate forms that are completed in anything other than capital letters. The UCC does not make this distinction, but a few filing offices are realizing that this is a ploy that can be used to cause delay in the filing of the financing statement of some secured parties and are using it. There's no basis for this policy. It is recommended that you follow the form as presented in military style. In other words, last, first, middle, and all capital letters. Once the filing is taken and the filing number issued, there's nothing to discuss. Number D, real estate filing. Same as standard filing in paragraph 12A above. Number 13, box 3C. Knowing what we know about the Postal Service, designations of an address and use of a zip code certainly pale in comparison with the incalculable financial liabilities associated with accepting free delivery of mail matter. However, these factors probably have some kind of bearing on how governments look at its subjects. As such, it is best not to use the zip code mailing convention provided by the federal government, as this could cause a presumption of accepting benefits and privileges. A. Standard filing. In care of number of street and box mark mailing address, city and box mark city. De jure 2, 3, 4, or 5 letters. State abbreviation is found in the dictionary and in the date lines of newspaper articles, complete with a period following, if possible. In box marked state, near zip code in brackets. In box marked postal code, USA, and box marked country. B. Cross filing. Again, since this party and his or her mailing location will vanish upon the filing of the first UCC financing statement amendment, it is recommended that the filer enter address designations as done normally by non-secured parties. C. Real estate filing. Same as standard filing in paragraph 13A above. 14. Box 4. Here is the standard blanket collateral description for each type of filing. Collateral description. Number 1, preferred stock certificate issued as birth certificate for John Henry Doe's number, birth certificate number as received by the state Vital Records Department on, and you're going to put your date of birth, and the pledge represented by same, including the bond issued and sold by the United States Department of the Treasury and Commerce, bought by the Federal Reserve Bank, and held in trust at 55 Water Street, New York, 10041 by the Depository Trust Company, DTC, and traded on the Circle 750 Stock Exchange for the settlement of all debt, public and private, predicated on the United States and the vessel described above as the debtor, but not limited to the Pignus, Hypotheca, Hereditaments, Rays, and the Energy, and all products derived therefrom, including, but not limited to, the Bailee, all cap name John Henry Doe, and all the different appellations you can spell your name, or any variation or derivation thereof, and all signatures on all contracts, trusts, and agreements predicated on the United States and the vessel described above as the debtor. Number 2, you're going to put your state and your driver's license number. Number 3, your Social Security Administration Form SSA 3699 document for account number, including but not limited to employer identification number, CUSIP, and Auditress International tracking numbers. And this is all referencing your Social Security number and your Social Security number without dashes. The Auditress is something that is actually tracked by the government. It means automatic tracking identification system, as you can see. And this is something that is used by local and federal governments to track you. It's within their system. Number 4, registered master bond. And you're going to put your registered mail number that's going to be placed on your bond. You should have 2 registered mail certificates already from the post office. Your foreign citizen prepaid trust number, your birth certificate number that's off your birth certificate, and Sestway K trust numbers, which is your Social Security number with dashes. Okay, your Social Security number, SSN without dashes, and your private offset account number, which is on the back of the SSN. Now, number 5 is your EIN number, your 45 number. You should have those, your corp number, your trust number. You have 245 numbers and a 98 number. Those will be addressed in another video. Your U.S. Department of Transportation number. This is optional. Some of you may already have one. Some of you may not. Number 9, your passport number. Number 10, your offspring's birth certificate numbers. All your children's birth certificate numbers, you claim those as well. Your marriage certificate number, put that on there. Future proceeds, tracking assignment numbers. These are your negotiable instrument numbers. It's no different than when you go in a bank and you get check numbers. You decide on what kind of convention you're going to use with your negotiable instruments. Some people put their initials in front of their numbers. Some people don't. It is your decision. But whatever numbers that you use here, you have to stay consistent, because what you're doing, you are pre-claiming those negotiable instruments. That's what you're doing in this section right here. Very important section for you to understand in number 12. Number 13, obligation of debtor in favor of secured party as set forth in the express written security agreement number, and you're going to put the security agreement number that you applied to your security agreement there. Amount of said obligation, 100 million United States dollars. And once again, this can be any amount that you have put on your security agreement. We use 100 million because Allegedly, that's how much it costs to get on the trading platform. However, I have no evidence or anything that a specific number needs to be used because your exemption is unlimited and no one can tell you what you are worth, what your value is. And you realistically can put any amount on your bond that you want. Number 14, all property is accepted for value and exempted from levy. Adjustment of this filing from Public Policy HGR 192, Public Law 73-10, the Law of Trust, and you're going to put your state right there, Uniform Commercial Code 10-104. Every state has adopted the Uniform Commercial Code. Louisiana was the last state to adopt it, but all 50 states now have accepted the Uniform Commercial Code. Okay? All proceeds, products, accounts, and fixtures, and the orders therefrom are released to the secured parties, United States vessel, and all account information held by the Federal Reserve Bank, Depository Trust Company, and the United States Department of the Treasury by power of attorney is hereby revoked, and all trustees are fired due to the several counts of bankruptcy obstruction. Nominated and appointed trustees is transferred to the secured party authorized agent, also known as the authorized government contracting agent. And this right here, the vessel is the word I want to concentrate on. This is an admiralty term, and you really should watch the video I have on my YouTube page about the secret jurisdiction, admiralty jurisdiction, to understand that this is admiralty. It is the law of the sea. However, it applies on land, and there's plenty of case law that is available in the public that tells everyone this. We're operating in commerce. The legislature it was never really supposed to have admiralty jurisdiction, but when they created this fictitious jurisdiction that they had the right to do due to their plenary powers under Article 1, Section 8 of the Constitution, they created a separate jurisdiction where they established their own rules, so to speak. And they have this colorable type of admiralty jurisdiction that is going on, and they are contracting with you and bringing you into that jurisdiction. And in admiralty, these are vessels. You are looked at as a vessel. So whenever you see this word vessel, that is what that is referring to. It's referring to you, your body, your labor, and your energy. Now, A, standard filing. The literal spelling out in words of the document date as shown above is a common law, non-statutory designation of the date. In other words, a way of distinguishing between the common law and statutory law. And this you'll see a lot on a lot of documents in the year of our Lord or spelling out the actual date. Okay, all of this is significant. I mean, they have their own way of doing things in their jurisdiction. It's all fictitious, and you need to learn how to get in the habit of distinguishing in your documents the common law versus the statutory way of doing things. Okay, this is actual and constructive notice of claim held by secured party in the entry of the debtor in the commercial registry, and the following property is hereby registered in the same but not limited to. Okay, and that is the way that you write that. B, cross-filing. This is the text for the initial cross-filing only. Collateral descriptions for subsequent cross-filings are provided in the next section. Section 9, UCC Financing Statement Amendment. You cannot use verbiage similar to the following due to UCC 9-108, super generic description not sufficient. You know, you'll see people tell you all assets that belong to the debtor belong to the creditor. And you can't use that. Those are super generic descriptions. And UCC 9-108C tells you that you can't do that. A description of collateral as all the debtor's assets or all the debtor's personal property or using words of similar import does not reasonably identify the collateral. You have to reasonably identify the collateral in your collateral description. So here's an example. Here's an example. And here's an example of something you shouldn't do. All of debtor's assets, land and personal property, and all of debtor's interest in said assets, land and personal property, now owned and hereinafter acquired, now existing and hereinafter arising, wherever located, described fully in security agreement number, and then go put your security agreement number, dated, and any date earlier than the date that will be used by you. Okay, you can't do that. It's not a good example. All right. Now, down here at the bottom, you're going to see a lot of people have various ways of filling out the bottom part of their UCC1. And I'll quickly go through each one of these.
Number 5, check only if applicable and check only box. Collateral is held in a trust. I deal with trusts. I usually check that. Or is being administered by decedent's personal representatives. Some people will check this because the decedent, the straw man, is looked at as a decedent, and they will check this. And let me tell you this. I tend to try to stay away from things that can be construed as some sort of straw man filing or is going to lend some confusion or something, because people in the public try to act like they don't understand what you're talking about. And this is a very big reason why I kind of stick to trust so much, because trust is something that they do understand. And working through a trust seems to help alleviate a lot of the confusion or pretending that goes on their side of the fence and so forth. So I tend to check that it's held in a trust. Right here, they'll say check only if applicable. 6A, some people have been using public finance transaction. The old school way is to use it as a debtor is a transmitting utility. You will also see in 6B, some people like to put it agricultural lien. This is because we're being looked at as farm property. Gene Keating talks about that a lot. You would need to know how to do an agricultural lien. Very few people know how to put one of those together. And of course, lately we've been having a lot of non-UCC filings. Non-UCC filings is for property that is being put somewhere else. A lot of people, they came up with a Minnesota Rule 220. They were using that the birth certificate was a certificate of title, and they were filing certificate of titles down in the real estate records. I am not with that. This doesn't make any sense to me, and I haven't seen any evidence that it was. You can look at my video, Finally, the Truth About Minnesota Rule 220, if you have any differences of opinion on that, and you can see that right here on my YouTube page. Okay, alternative designations, that is non-applicable. Optional filing, reference data. Some people will put some additional data in here I'm sorry, let me go back to 7. 7. And 7, alternative designation. Number 7, alternative designation. They usually check Bailey, Baylor, and optional file a reference data. You can put something right here if you choose to. If not, that's on you. Now back up to the number 5, you'll see a UCC1 addendum, item 17, and instructions. This is where you would put the addendum, and we're going to take a look at the addendum next. Okay, and that's it for this section, and you are ready to move on to the next section.